What happens when the ERISA disability insurance company fails to respond to the complaint that my lawyer filed in federal court? Under the ERISA statute, you have to exhaust your administrative remedies, which means you have to file your appeals and have them deny the claim before before you can file a lawsuit in federal court. It's called exhaustion of remedies. So let's say you file that complaint. That complaint is served on the disability insurance company, and they don't respond to that complaint in 20 days. What happens? Well, your lawyer should be filing a motion for the entry of a default. The motion will say, we filed the complaint on a certain date, the complaint got served, this time has passed, they haven't responded, here's an affidavit from me supporting these allegations. Please, judge, grant my motion for a default. Once the court does that, that doesn't necessarily mean you win, because you really want to move for a default judgment, because the judgment says, hey, they didn't answer, the allegations in the complaint are now considered to be true, and we want a judgment in our favor. In both instances, in both motions, your lawyer is going to be filing this with the court, but they have to legally serve the insurance company. And when they do that, generally, the insurance company will wake up, and they may have a lawyer then make an appearance. Your lawyer is going to be asked, well, can we agree to vacate the default? And I generally say, no, I'm not going to agree to vacate the default. But if the judgment has already been, entered, then, I'm going to argue that that's something that I can use to get this case settled. Now, their response is they're going to file a motion to vacate the default judgment. And I will tell you that federal judges are unfortunately very sympathetic to disability insurance carriers and will most likely grant that motion and, just sort of wipe clean, if you will, the default judgment. I've never had a judge not to do that. Now, conversely, I've had judges deny claims because the employee has failed to exhaust administrative remedies, and while that's not fair, the deck is really stacked against you. The judge will be inclined to give more favor, if you will, to the insurance company and say, okay, look, I'm going to vacate this motion that order that I entered on the default judgment. But again, I think it's a tool that your lawyers can use to help bring about an appropriate resolution of the issues. If you have any questions about your rights to your ERISA disability insurance benefits, contact me today at 727-894-3188 for a complimentary consultation. I look forward to helping you get the disability benefits you deserve, regardless of where you live in the United States, regardless of who your disability carrier might be, and regardless of the nature of your disability. 727-894-3188.